right, welcome back. So we're still in the chapter on discretion, and this week we'll look mainly at how to review discretion, which is something that we looked at briefly before in the context of discretion, but also in some other contexts, right? So trying to see both the grounds of review, so the reasons for which you can seek review before a court, and also the standard of review that will apply to all of these issues. So we looked at a number of issues before, which, as we said, were mainly preliminary, right? So we said some issues as to jurisdiction are generally preliminary. So you're looking at whether the decision maker has the power to make a certain decision in the first place. Sometimes there will be a decision as to jurisdiction, which will also be kind of a preliminary decision. So the decision maker will say, I've looked at the statute and I've determined that I do or don't have the power to make that decision. That will be a decision as to jurisdiction. It's also preliminary in the sense that it's not the substance of the decision. So if you're asking a decision maker to do something, right, such as issuing a license or deciding on whether someone is going to be sent to some other country, that's the substance of the decision. And when they make a decision as to whether or not they can make it, right, that's not the substance of the decision itself. Same thing for a bunch of other things we saw, often constitutional issues, delegation, statutory interpretation, all that is essentially preliminary. Discretion is the substance of the decision, right, but it's also kind of a hybrid because it looks at the flexibility that the decision maker has in making a decision. So we looked at discretion before. We said discretion is basically when the statute says that a decision maker can make a decision with some wiggle room. And that essentially means that there's more than one potential decision that can be made in this specific case or not be made. So for instance, you might say, right, this person will be, I think the example we use is immigration, right? So a person has to be sent back to their country because the law says that. So the law has a 5-part test to assess whether or not they'll be at risk in their country. If they're sent back, right, you apply the test. Turns out that they won't be sufficiently at risk, therefore, right, they have to be sent back. Then there is a power that says that the minister, and as we said, right, that doesn't mean the physical person who's the minister can make a decision on humanitarian or compassionate grounds, that's actually what it says in the statute, to exempt the person from the requirements of the Act, of the Immigration and Refugee Protection Act. So what's that mean, right? It means the requirements of the Act or the test that says they'll be sent back to their country, right? So they have to be sent back. Then if the minister grants a waiver from the application of the Act, they're granting a waiver from the application of the test and therefore, right, essentially removing the need that they be sent back to their country. That's an example of a discretionary decision. So the minister doesn't have, right, first he's given a pretty broad power. It just says on humanitarian or compassionate ground, unlike the prior decision, right, which was made by, say, applying a 5-part test to look at something, and then if the test is met, the person meets it, they're gone, right? Minister has more of a discretionary power. There's no test, right? It's just, right, essentially if it seems unfair, the government's decided that it wants there to be some ability for someone to remedy that, right? That's often how statutes work, right? Statutes are going to have words and tests that don't provide for all potential situations. Sometimes there's a situation where, right, if the person who passed the law and government knew about it, they certainly would have said that person should be exempted from being sent back to their country. But because you can't anticipate everything to start with, right, you have to later on provide for a discretionary power to essentially waive the application of the Act. So the power is purposefully broad. It's not defined. And oftentimes, it doesn't even have to be exercised. So the minister can say, right, this person, I decide not to exercise the power, even if there's a pretty similar case where they did, right, because it's not a mandatory power. Therefore, there's also discretion not to exercise it, and as long as it's consistent with, right, the purposes of the Act. There's also no need really to follow prior decisions that have been made. Naturally, discretionary decisions will be subject to, as we said last week, reasonableness review, right? It's kind of the same definition. A discretionary decision is you have multiple potential outcomes, right, or no outcome at all that the person can decide on. That's kind of the definition of reasonableness review. Reasonableness review is, right, as long as it's within a reasonable range of outcomes, even though it's not the best outcome as a decision or the outcome that would have been reached by a judge, right, the decision has to be upheld because it's considered to be reasonable. Then there are two issues there, right? First, how do we review, why do we review a discretionary decision, which is what we'll look at now, and then how. The how is the standard of review, right? So the why first is the grounds of review. So how can you review, why can you review a discretionary decision? As we said, even though the power is broad, it doesn't mean that it's indefinite and that the person can do whatever they want. And that's true even though the statute will say that, right? Typically the statute will say it's a purely discretionary power. So my example, right, on humanitarian or compassionate grounds. We looked at that before. Doesn't say that it can't be discriminatory, doesn't say it has to be fair between different claimants. It's entirely broad. So it could be exercised discriminatorily, for example. But as we said, it doesn't work that way, right? Even if you have a broad and discretionary power, and even if it's defined that way in the statute without limitations, as it almost always will be, you still have certain constraints that apply by virtue of the Constitution. First, the Constitution, which provides for certain due process, procedural fairness, and all that protections. And now, of course, the Charter, which allows you to do that more implicitly. We said it more explicitly. So at first, there was something called abuse of discretion, where you could essentially strike down a decision that was discriminatory or unfair. Now you can also often do that by virtue of the Charter, which specifically provides for that. So because a decision can always be reviewed, again, pursuant to reasonableness review often, right? And because a discretionary decision does not imply that the person can do whatever they want, there are specific issues that will trigger a review, right? Where the court will step in and find boundaries to that power, which otherwise is pretty broad, right? Otherwise, they have a broad power to exercise it for a bunch of different reasons, in a bunch of different contexts, or not exercise it at all. But at some point, it's going to become a problem. So the court essentially draws boundaries around that to avoid certain things that are protected by the Constitution, often having to do with, right, the decision being unfair or being exercised in a way that's not consistent with the power. So in a way that's not, right, why the power was granted in the first place. So, first one is an error of law. It's something that we see where often there's less deference, right? So one example is on appeal, you've got the same thing applies. If you go on appeal before the Ontario Court of Appeal, you don't have a right to say, right, the decision at first instance was wrong for any reason. It doesn't work that way, right? Depending on what you're claiming, a different standard will apply. If it's an error of law, there's often no deference. So the Court of Appeal will look at the law, decide whether or not it was correctly stated. Then when you get into the application of the law to the facts, or when you get into the facts themselves, determination as to what actually happened, there's a lot more deference. So same thing for a discretionary decision. If the decision maker misconstrues the law, right, and to a lesser extent if they misapply the law, then that is reviewable, again on a standard of reasonableness. Usually errors of law would be reviewed more on a standard of correctness, but because there is further deference for discretionary decisions, it's reviewed based on a standard of reasonableness. Then we get into essentially misuse of the power, right? So bad faith is a pretty broad category that essentially encompasses all the other ones, right? The other ones are you ignored something you had to consider, right? you consider something you should not have considered, or it was unfair. All these three things also count as bad faith, right? Bad faith is you exercised the discretionary power that you were given in a way that was mischievous, and therefore it's broader. So oftentimes you can claim that and the other things, right? But the other ones are more specific, so usually they are the ones that you'll claim, right, to simplify things. So because it's older, it's broader. It implies a specific positive action being done, right? So bad faith implies, right, not the absence of good faith. It implies bad faith. So it doesn't just imply that you did not act in good faith. It implies that you acted in bad faith, which means that you specifically voluntarily did something wrong, right? So you have to have, right, some voluntariness to the action, some deliberate conduct, quote unquote, right? You have a pretty helpful list there, which is helpful to remember, page 232, right? It's been held to include dishonesty, fraud, bias, conflict of interest, discrimination, abuse of power, corruption, oppression, unfairness, and conduct that is unreasonable. So again, pretty broad and long list. Again, almost never used. But you see the kind of things that fall under what courts can review a discretionary power based on, right? Things having to do with the decision maker being dishonest or biased, as you'd see with a court, right? So they take a bribe, they refuse to hear you, they decide the case because of their political allegiances or their personal preference as opposed to the actual stuff that's before them. And then you look at, right, some procedural fairness issue, whether they heard you, right, they were fair to you or abused their power. Again, very rarely used. And there's always a presumption, especially for the government, that they are acting in good faith, right? So if you want to show that someone is acting in bad faith, which requires, again, intentional conduct, you have to show that. The burden is on you to show that, right, to rebut the presumption that a decision was made in good faith. And it's especially true for government action, as we saw earlier. So when the government enacts a bylaw, a law, whatever it is, there's a presumption that it's enacted for a proper purpose, right? The government isn't trying to do something else in hiding that's bad, right? And so if you want to show that, you have to prove it because there's a presumption of good faith. Often you'll see that, right, you have examples there, page 234, where the power is exercised for an improper purpose, which, as I just said, is now also a separate category. So, for example, you'll recall, right, you have an example there, I think, with an electrical generation facility, and the permit is denied for some other reason, having nothing to do with, right, what the permit's supposed to be issued for. And that's an example of an improper purpose, right? So even though you have this broad power to issue a permit or not, and even though that power is not constricted by the statute, so the statute doesn't say you've got to consider these 5 things. It just says you can do whatever you want. Doesn't mean you can do whatever you want in a way that's inconsistent with why you were granted that power. Same thing with the Roncarelli case, which you might recall. Guy in government has the administrative power to issue a liquor license, and then either revokes it, I think it's revokes it, or issues it for a specific reason that's essentially discriminatory. I think it was religious discrimination. So again, right, even though the power is drafted broadly, doesn't mean you can essentially abuse it to do something else and exercise it for an improper purpose, essentially, which is also a different category but falls under bad faith as well, right? And again, you have intentional conduct, right? It's clear that the decision maker thought it through, right? They thought, I want to punish someone for religious reasons, and the way I'll do that is use the power that I have. And the power that I have is to not grant them a liquor license. The remedy is always the same, right? So the remedy at the end is always that you quash the decision. We said that multiple times. The default remedy is always that you quash the decision. So If there's a decision, it's unreasonable or incorrect after applying the standard of review. The remedy that you apply as a court upon judicial review is to quash a decision. Essentially, you cancel it. So it's a decision that's been made illegally, and that decision has to be canceled because it's been made illegally for one reason or another, right? Including if it's unreasonable. But what you do is you cancel the decision. You don't issue a new one. You don't substitute your reasons for those of the decision maker. You simply cancel the decision, and then it goes back to the decision maker, right? Usually some other person, but the administrative decision maker to make a decision that's compliant. Because again, right, we want to favor the underlying principles of administrative law, right? Fairness, efficiency, cost effectiveness, all that, and that's why we send it back for it to be made pursuant to the same process, which is supposed to have these various advantages. It's still true here, right? There's a bunch of other remedies which we'll look at later in the term, but the default remedy remains the same. Then you have, they're lumped together, they're lumped together at page 236, but they're actually two different things, right? So irrelevant ground or improper purpose. So again, they're lumped together because they're similar but slightly different, right? Irrelevant ground is you consider something that you're not supposed to consider. So for example, right, it might have a three-part test. It might say that you have to exercise your discretion, and it would still be discretionary, right? But by having due regard to A, B, and C. Well, then you have to consider A, B, and C. And oftentimes that will also mean that that's what you're supposed to consider. So depending on the interpretation of that, you might or might not have the power to consider something else. And even if it doesn't imply that you don't have the power to consider something else, right? Even if when you interpret it, it seems like it's three things among others that can be considered. So you've got to do the three, but you can add some. It doesn't mean that you can consider something else if that something else is completely irrelevant, right? So say the race of the person, right, in an immigration decision. Even though you have the power to consider other things, that's not one of the other things that you could consider. It would be an irrelevant ground. It might also be discrimination pursuant to the charter, which would be another reason you can invalidate. Again, these are not mutually exclusive. In fact, would also be bad faith, which again is almost never claimed, but it would be bad faith there, right? Because intentionally, you are denying, say, a license or the person going back to their country on the basis of race, which is clearly something that, right, is unfair, and you're doing that voluntarily. So it's an irrelevant ground, and that can be true when there's limited stuff you can consider, or when you can consider anything, but you decide to consider something that's just not a thing you can consider because it's completely unrelated and or unfair. Improper purpose is, right, you essentially abuse your power. It's slightly different, right? So you use your power in a way that's detrimental to the person. And it can be for a bunch of reasons, including that, right? So if you're denying something on the basis of race, right, not only are you considering something that you're not supposed to consider, you're also letting that influence your decision, and you're exercising a broad power that you were given for an improper purpose, right? You were given that power to help people who show humanitarian and compassionate considerations, and therefore just don't deserve to be sent back to some other country, although the legal test says so. That's the purpose. If you start denying it selectively on the basis of race, you're exercising that power for the purpose of discriminating, right, or for the purpose of excluding people of a specific race from the country, and therefore that is an improper purpose. It's not the purpose for which you were granted the power, and it's not a purpose for which you can exercise the power. And often, right, in both cases, it's something obvious, right? It will be clear that this ground or purpose is clearly not something that was planned for under the statute, and is clearly not something that you'd expect the person to exercise their power for. And you have a number of examples, right? Page 238, Shell Canada versus Vancouver City. Essentially, they deny, right, a business, I think they stopped buying from it, essentially boycotting it for a specific reason, right? Because they wanted to change its policy of doing business in South Africa. Again, right, it's an abuse of a power. Yes, you have the power to decide who you buy from or who you issue licenses to, but that power was granted to you, right? Clearly not for the purpose of trying to change, right, the policy of a company in some other country, and certainly not when you're a city, right, as opposed to, say, the federal government. Then you have the Baker case, which we talked about before. Baker case has, right, the standard of review for issues of procedural fairness. That's what we looked at it for, right? We said in Baker that the Supreme Court said essentially that it was confused, that there is no actual standard of review for procedural fairness issues. The court said it's neither correctness nor reasonableness. It's just a standard that varies depending on the importance of the decision you're making on the person's life. That triggers some procedural fairness protections, right? That's what we looked at the Baker case for. But then you have an example, I think, that's somewhat interesting, right? So Baker case, the actual substance of it, before the court created some new law, was an immigration case, right? So you had you have essentially when you want to ask for something pursuant to the Immigration Act, the same act we just talked about, so Immigration and Refugee Protection Act. If you want to ask for something, right, you have to submit your application in Canada. Sometimes that won't be possible, and so you can ask to be exempted from, right, the obligation to make your application outside of Canada. So, sorry, I think I misspoke there. So, usually, you have to make your application outside of Canada, right? Because if you made your application from within Canada, it would essentially mean that you showed up illegally and then went to the consular office and said, right, hey, I want to get permanent residence. Usually, we don't favor that, right? And therefore, we force people to make that decision for that application from outside of Canada. You can be exempted from that pursuant to the Act, right? And that decision is made by an immigration officer. So some guy in a government office somewhere, right, the Canadian Embassy, will make that decision. And that's an administrative decision, right? Because you've got someone who comes, they have a right pursuant to the Act to make an application for permanent residence. They also have a right to ask to be exempted from the requirement to make that application outside of Canada. So that's the decision that affects your right? Because in fact, if it's denied, you're done. You don't get to apply, and that's made by an immigration officer. And you see something there called the officer's note, right? In fact, it's a system we call the Global Case Management System, which is this government system where you have the notes of the officers. And that's what it looks like. That's what it actually looks like. Page 238 and 39, you've got a couple lines of text, right? The guy says, I have met with the applicant. I have read their application, which is usually 20 or so pages. And I have decided, right, to deny the application. And that's it, right? Again, that's a decision that might have been made by a court, is given to the administrative system. Then it changes everything, right? You don't get a lawyer, you don't get to make submissions, you don't get witnesses. On top of that, it's made by some guy who's clearly not a lawyer, and that guy doesn't issue formal reasons for their decision. We said there's no requirement pursuant to Vavilov for there to be formal reasons for a decision, for there to be a 20-page document where the guy says, in detail, this is how I made the decision, right? Takes the ingredients, these are the facts, this is the law, I combine them, this is how I've decided. So that's what it actually looks like, right? Couple lines of text, and that's the reasons for the decision. So if you show up in court, you seek judicial review of that, the court has to do with what it has. It has to look at the 3 lines of text. If that's not enough, it can look at the record. It can look at the documents that were before the decision maker, use that to interpret the 3 lines of text, and to the extent that with all that together, it can see how the decision was reached, then that decision will be reasonable. Because there's no requirement, again, for there to be formal reasons, for them to look a certain way, or even for them to be freestanding and not need to be interpreted with the record. Then the guy, right, essentially exercises his power discriminatorily. He says, right, there's 4 kids, it's something you've got to consider, best interest of the children. Almost always when they're kids, right, people will get what they're asking for under immigration statutes. I don't think that's my political opinion, I think it's a fact, right? Like, usually if you have someone who commits a crime in Canada, for example, they're denied permanent residence, but if they have children who've been established in Canada for a certain period of time, right, they'll be able to stay anyway because you don't want to punish the children for the thing the parent did. Same thing there, right? She has 4 kids, right, who are in Canada. So ostensibly she would do it. She would get what she's asking for, which is an exemption under the Act. But then the guy says, right, it seems like she meets the criteria under the Act, but I am of the opinion that Canada can no longer afford this type of generosity. Again, that's an example of a lot of things, right? First, it's bad faith, right? Because you're intentionally denying it for a reason that's not legitimate, namely that you have a personal political opinion that's not provided for under the Act. It is also the consideration of an irrelevant ground, namely your opinion as to, right, how much of a burden people are on the Canadian welfare system. And it's also made for an improper purpose. Okay, then you have another ground, again, for judicial review. So all of these are grounds of review. So all of these are limits to a discretionary power. So usually it's broad, usually it's indefinite and seems infinite, right? But it doesn't work that way. There are actual limits to it, and these are the things that you can review it on. Again, once you decide that, you have to look at the standard of review, and by default, that's always reasonableness, even for, especially, for a discretionary decision. Okay, so the other thing you can do is fail to consider a relevant ground. It's the opposite of the first, right? And it's actually a lot simpler. So for an irrelevant ground, you'll have, right, A, B, and C. And then the guy just, right, does not ignore that, but he considers something else. And that something else he might be allowed to consider sometimes, right, depending on whether the list is exhaustive or not. But he can't just consider something that's completely unrelated and unfair. The simpler version of that is, out of the 3 things he has to consider them. However, sometimes it will be more subjective, right? So sometimes, for example, right, it just won't say what A, B, and C are because it doesn't have to. So if it says in my immigration example, the guy can grant a compassionate waiver on humanitarian and compassionate grounds, he's going to be expected to consider all relevant factors that would count. So all the things that, right, make people, make us have compassion for people, he'll be expected to consider them implicitly. Because the power is drafted broadly, right? And if, say, there's kids involved, that's clearly a compassionate ground. If he fails to consider that, he's failed to consider a relevant ground, even though it's not explicitly provided for. So anything that, right, makes us feel compassion for the claimant, the person will have to consider. You have an example, page 241, right? There's a requirement for the minister to appoint a labor arbitrator in the CUP case, right? And then the minister starts essentially not considering whether the people have any labor law experience. Again, that's failure to consider a relevant ground, right? Clearly, if your job is to appoint a labor arbitrator, again, when it's not provided for in the statute, when the statute doesn't specifically say these are the things you'll consider. You have to consider the relevant things, and clearly, if you're appointing a labor arbitrator, that would include having labor law experience. Okay, then the last issue is fettering discretion, which is something we might have alluded to earlier, but really not in that much detail. Essentially, an administrative decision maker is allowed to limit their discretion voluntarily. And often they'll do that, right? It sounds kind of weird. You've got a big power. Power says you've got to consider humanitarian and compassionate grounds, right? For example, why in the world would you want to limit that, right? On top of the fact that the government just told you could do whatever you want for humanitarian and compassionate grounds. And the answer is usually to provide for some predictability, right? So if you have an antitrust power to break up companies for the benefit of the proper administration of Canadian capital markets, right? That's very broad power. That means there's a million reasons why you can exercise your antitrust power. It's not necessarily good, right? It's going to scare a lot of companies who just won't know what to do, right? They just won't come to Canada to do business because then they don't know why or if they'll be broken up, right? And so there's no way for them to do what they usually do with the law, which is, right, read it and then adjust their conduct to make sure they're compliant. So as an administrative entity, you might decide, right, I will issue a bunch of guidelines that will say this is how I generally exercise my power. And these might be binding or they might not be binding, right? If they're just released, by default they're not binding. However, there's also a doctrine that we briefly alluded to earlier, which you probably won't remember, which is the doctrine of reasonable expectations in administrative law. So although it is not binding, because it'll say, right, these are the things we usually consider. It's going to say sometimes as opposed to always, right? Usually consider. It doesn't say these are the things we systematically consider and you have to meet A, B, C, and D. That's the distinction there. However, if you do that for a long period of time, so if the guidelines have been out for 10 years, then people can start claiming that because it's been so long, they have a reasonable expectation, that's why the doctrine is called that, right? That it will be applied in the future because it's been applied in the past. And then, right, you might have a positive obligation not to change the guidelines, or at least not to change the guidelines without proper notice. So you're allowed to do that as a decision maker. You're allowed to issue some guidelines or anything that limits your discretion, right? That limits your power by explaining to people how you exercise it and then exercising it compliant with that, right? So if you say, again, they're not mandatory. So these are the things we usually consider, for example. Doesn't mean that that prevents you from considering other things. It also doesn't mean it prevents you from changing it. Say you're changing it slightly. However, there'll be an expectation, right, that you'll respect that. And therefore, you're limiting your discretion. Now, it's not just I'll do whatever I want because the statute says I can do whatever I want. That's allowed, right? But not if it limits your discretionary power too much. So if you start saying, these are the things we always consider, that's usually how it'll be phrased, right? And only these things. Then the problem is, first, you no longer have a discretionary power. A discretionary power is you can do whatever you want, pursuant to, right, while respecting the general bounds of the law, right? So procedural fairness and all these things there. Now if it says, these are the things I have to consider, and I always consider them, it becomes mandatory. And therefore, it's essentially as if you had a four-part test in the statute. You can no longer do whatever you want. You no longer have a discretionary power. You just systematically have to apply that, and that's not allowed because it essentially removes that discretion entirely. If it removes it substantially, it would also be a problem. The underlying reason for that, which is also important, is that usually you have a discretionary power precisely to avoid a test, right? So you'll recall in my immigration example, there is a test that says if you've got A, B, C, and D, right, we don't send you back to your country because you'll die. Then you have a power to waive the application of that on humanitarian and compassionate grounds. Well, the point of that is so that someone can actually think, right? It's so that someone can sit down and say, this is the person there, this is their story, and it's just not fair, right? And there's no test for that. In fact, the test might say otherwise. That's why you need the power. You need the power because you want justice. You want something that's more subjective, something that's more personal, and say it's just not fair to that person. And that requires wiggle room. It requires what we define as a discretionary power. And so if you start limiting your discretion too much, you're also defeating the underlying purpose of having a discretionary power, which is to have a wide ability that allows you to often, right, derogate from the statutory criteria for reasons of, right, fairness and other issues that we want to advance. And that's why, right, there will only be limited limits to that, right? You can deny to exercise your power. You can exercise your power for all sorts of reasons. As long as it's not something completely outrageous, right, the court will allow you to do that. And again, you're allowed to do that, right? So you'll need to interpret whether or not the guidelines say that were issued were mandatory or not, and then what the consequence of that is. But there's no rule that says, right, the statute has to say you can issue guidelines that fetter your discretion. It doesn't work that way, right? You have the power as an administrative decision maker to do that in the first place. You've got two examples, page 246, right? Not that important for our purposes. Essentially, right, in one example, they have a policy that they never give the Crown costs. What's the problem with that? It's the never. There's no more discretion, therefore it's no longer discretionary power, right? Same thing, the other example, right? Never issue costs to, never issue compensation for a certain type of expense. Again, same thing, right? The problem with their policy is that it overly limits, and in fact entirely limits, right, their discretionary power. Then you have certain issues as to stare decisis, which we briefly discussed before, but which are important, right? So first, it does not apply, and second, sometimes it does, right? So as a general rule, right, an administrative tribunal does not need to follow their own case law. We said that. We said it's not like a court. There's no requirement if something's been decided a certain way before to follow it. And in fact, that can have weird consequences. For example, if it's a decision of a constitutional nature. So you say something violates the charter. As an administrative decision maker, you cannot strike it down. You say it doesn't apply because it's not compliant. Well, it doesn't mean the next guy with the same claim has to also decide it infringes upon the charter, because there's no case law. You can do whatever you want. The reason for that is that, right, you're supposed to have discretionary. You're supposed to have, right, discretionary power, essentially, right? I changed myself. You're supposed to have discretionary power, which is essentially the power to make a decision that's more responsive to the case before you, which is why you don't have to follow the case law, right? We want you to be able to respond to the specific facts before you, and that's why we say you'll be able to decide however you want, even though there's a very similar situation that was decided a certain way, unlike in a court. That, right, is because administrative law, right? It's because we want it to be cost effective, because we want to have expert decision makers, and therefore that have, right, a special ability to look at very specific cases, because they're experts on the one thing that they look at. But that is essentially a discretionary decision. The ability to decide on the specific facts of the case. Same thing as my compassionate waiver, right? There's no rules, really. You don't have to follow the rules because you are supposed to, right, have more than one possible outcome, and that's essentially discretionary power. There's one exception there, which is when there is a general statement of principle that's laid out, then it has to be followed. That's extremely rare, right? But it would manifest itself as a kind of long-standing practice that's been adopted by a certain tribunal that then has to be followed because it's general and has always been applied, right? Again, the default rule doesn't change, and that is that there's no case law in administrative decision making. Okay, then we get to the standard of review for all of that, which is reasonableness. So all these things, right, these are the grounds of review. I won't repeat it again, but these are the reasons why you can seek judicial review. So when you show up to a court, these are the things you can say. So Guy in the government office has a discretionary power. You want to say that it's not legit what they did. They have the power of a king, essentially, so there's limited limits to that. That's the whole point. These are the limits. These are the grounds of review. These are the reasons why it can be an illegitimate exercise of that power. Then the question is, so you're there, right? That's the claim you make before the court. The court says, okay, we will have to examine that, what you're claiming, right, improper purpose. Then how does the court do that? That's the standard of review. Court, right, is going to have a method, right, to look at the decision, because it's not like a court, right? Court has the facts. It's got people, documents, and then it looks at the stuff, decides what happens, and applies the law. There it's not the same thing. Someone already made a decision. It's kind of like an appeal. So someone already made a decision. Court has to take it and see if it's legit. And court, again, doesn't do it over, just like a court of appeal. So how do they conduct that review? How do they check whether or not these things are legit? And the answer is, by default, by conducting reasonableness review, which makes sense, right? Again, because it's discretionary. The whole point of the power is you can do more than one thing or nothing at all. Therefore, the court is going to show proportionate deference in not checking, right, what you did. So even if it's one of the few things you can seek judicial review on, it will remain a very deferential exercise. That's why the standard remains reasonableness, right? Even though these are things that seem outrageous to start with, right? If it were non-discretionary powers, these would be things where much less deference would be showed. So, much different from jurisdiction, right? Jurisdiction is whether or not they can make the decision at all. This is much broader, and it makes a lot more sense for there to be a lot more deference than there was for these issues. The court will be even more deferential, page 260, when the decision is more policy-oriented or political, which kind of makes sense, right? When the decision is of a nature that's non-judicial, right, that is therefore more discretionary, more policy-oriented, the court will show more deference. You have certain factors that need to be considered in determining the standard of review. Again, you can seek review, right, even though the default standard is reasonableness. If you show that something is extremely outrageous, eventually you can get to correctness. But it's extremely simple because there's a presumption of reasonableness review, which applies. We said for jurisdiction it gets a bit complicated, but here, because the power is broad, right, the presumption will almost always apply. In determining whether or not, right, how much deference you show, so whether or not you can move to a standard that's less deferential, right, which today doesn't exactly apply that way, but it's still helpful to look at it, right? Doesn't quite apply that way because you've got a very strong presumption of reasonableness review, right? But you see factors that are relevant to consider, that were relevant to consider, and therefore can be interesting for you to understand this, right? First, the presence or absence of a privative clause or right of appeal. So, if the power of the decision maker is limited in some way by statute, that limits the court's deference. Again, because the government says you've got to consider this. Therefore, the court will be more willing to look at whether it was considered. Because there's a limit on the power, and therefore less deference when the government created it. Right of appeal, same thing. Government intended for it to be reviewed. And we'll see that with issues of unfairness as well. Right? We'll see with procedural fairness, there's a further consideration there, which is if you don't have a right of appeal, the decision's final or less likely to be reviewed, and that can make, say, a violation of your ability to be heard even more outrageous because you don't have as much of an opportunity, right, to show up somewhere else and say it was done wrong. Then the expertise to the decision maker, right, makes sense, right? The government creates an entity with decision-making power for it to have expertise, therefore the court respects that. Third, the act as a whole, again, statutory interpretation, which is going to tell you the nature and breadth of the discretionary power. Fourth, right, the nature of the problem before the decision maker, namely what we said before. If it's an error of law, the court's going to be willing to intervene because the court is an expert on issues of law as opposed to on issues of, right, mixed fact and law or just fact, period. So, again, presumption of reasonableness review. Sometimes, as you're told at page 263, which is extremely interesting, I think, it's going to be hard to actually apply, right? So, for example, right, you can tell some of them are easier than others, right? Essentially, if you have an irrelevant ground, right? If someone makes a decision, like, say, the Guy and Baker, right? Guy and Baker says, I'm denying this because even though the lady meets the criteria, it doesn't exactly say it that way, right? But he gives the facts as to why she would meet the criteria. It doesn't say she meets them. Then he says, I'm denying it because I think we're too generous in Canada, and therefore, right, it's going to be a burden on the social system. There, it's easy for the court, right? Court doesn't have to start getting into, right, reading the 200 pages of documents to redo the exercise. It's clear that it was made for an improper purpose, right? It's just clear from the face of the decision. However, it's not always that easy, right? Sometimes the guy will be discriminatory, but he'll be smart enough not to say it. Or the guy will fail to consider a relevant ground when the relevant grounds are not provided for. So it's not a checklist where you can see from the decision, right, oh, he did check A, B, C, and D. If it's not clear what A, B, C, and D are. So just compassionate ground. You still have an obligation to consider all compassionate grounds. It's just not clear what a compassionate ground is. Then the court really, even though it's conducting reasonableness review, is going to go further, right? It's not just going to look at it superficially, but it's going to have to go deeper to conduct the exercise, especially for some of those, especially for an irrelevant ground, or to establish an intention when an intention is claimed but is not clear from the face of the decision. And again, it's reiterated at page 264 that, again, there's no requirement for there to be reasons for a decision or for them to look a certain way, right? So the court is allowed to, right, use the record, quote unquote, the stuff before the decision maker to, right, kind of build it up. Not too much, but quite a bit pursuant to Vavilov. And we will stop there for chapter 5 and be back for chapter 6.